class is on 1031 exchanges, which I think is a great topic right now. As we see, we're already seeing rates are coming down. We're seeing a lot of things on the market now. And I do think that there's going to be a lot of people that are going to jump into it. So there'll be people that are selling and those same people will need to buy. So if you're not familiar with 1031 exchanges, now's a good time to freshen up on what they're about and what the requirements are. Now, 1031 exchange, by definition, 1031 is a section of the code. It's of the tax code. And what that section says is that, and I'm summarizing into simplistic terms, that a seller of real estate, if they're going to reinvest anywhere in the United States and they reinvest their entire proceeds, then they won't pay any capital gains now. They won't it won't even have to be addressed. And basically, I find that for me, I think 1031 is a great tool for estate planning. But also what you need to know is whether or not it's worth doing it. There are times when people will have a gain and will owe taxes, but is it going to be enough money that it's worth them reinvesting? Sometimes it is, sometimes it's not. Sometimes people just want to be cashed out of real estate and they don't have somebody that still wants it. But let's talk about all the gray that's involved in 1031s, because 1031 to me, I find it to be one of the areas of law that is more gray than almost any other area. And what I mean by that is when people are taking advantage of a 1031 exchange, there are certain pieces of it that are either recorded or they're not. In other words, you have 45 days from the date of sale of an investment property to reinvest in another investment property. It doesn't have to be exactly. 1031 is also known as like-kind exchanges. So the exchange can be anything. It could be that you own a hotel. It could be that you have an ownership as a tenant in common in an entity that owns a building. It can be a vacant piece of land, a single family, multifamily, anything as long as it's in the United States. You can't do a 1031 outside of the United States. So where it's gray is because when you're taking advantage of a 1031, you are not submitting anything to the Department of Taxation and Finance to prove the fact that this was an investment and why you don't owe the gains that you would otherwise owe. And what I mean by that is you sell a property and you tell your accountant it was used for this, you're going to give them whatever information you're going to give them. You don't send that in when you send in your returns. So the point being, until somebody is investigated or challenged, they're not going to have to actually prove it. And so it's more being sure you have the backup, because if you are audited and they go through the records and they see that you have a weekend home in the Hamptons and that's the home that you did as a 1031 like years ago, well, a weekend home is not an investment property unless, of course, you use it no more than 14 days a year and it's otherwise rented out. It's not an investment if it just sits there vacant for you to use under the 14 days. One of the things that the questions I often get is, how long do I have to live in a property to claim it was an investment property? Very common question. The problem with that question is that how the Department of Taxation and Finance looks at it is they say, okay, what was the property owner's intention at the time that they purchased the property? That's what they look at. So if somebody's buying a three-family home and their intention is that they're going to renovate it and rent it out, that's their intention. Their intention is an investment property. If they're buying a three-family and they're going to occupy one unit and they're going to rent out the other two, depending upon the numbers, that can work also. Because even though the owner of the asset may have had it as an investment and now they sold one investment and bought another investment, but if hypothetically they bought an investment, maybe the property is more and they're flipping the what they had into the other and adding to it. So so now what would happen is the owner of the property can reinvest from the sale of their first property, buy this new property, reinvest the full amount, get the full benefit, pay more money for it because he is going to occupy as their primary residence. Now, what's interesting about that is when they sell that property, they can 1031 the portion of it that was for business purposes only, and they can take the deduction on the unit that was occupied as their primary residence, which would be the 250 or the 500,000, whether you're single or married. The things that are not gray about 1031 is that there is no flexibility, not some, there is no flexibility with respect to how many days you have to identify the other properties that you will be required to close on within 180 days from the sale of the property that's being relinquished. So the property that's being relinquished, the property that's being sold, that seller who's going to make a reinvestment into another investment property has to identify, they have to list, and they have to tell this information to the designated intermediary who's going to hold on to the proceeds from the relinquished property and then use those proceeds to purchase the replacement property. The money from the sale of an investment property that is going to be rolled into a new property cannot go into the bank account of the owner at all. If it goes in, you lost the opportunity to do your 1031. If somebody's selling their investment property, they can identify up to 3 different properties that they will close on or can close on within the 120-day period from the time that they close on the relinquished property. Now, I mean 180 days. I said 180 from the date that they close on the relinquished property. Now, they can identify 3 properties or they can identify as many as they want, but they cannot do more than 200% of the market value of the property that they're selling. So that's the formula. Three properties listed or as many as you want, but no more than 200% of the market value of the asset that you're selling. Now, when you do close, you don't have to reinvest the sums that it cost you for the actual closing itself. So in other words, you can take off of your gain. So you're selling an asset. Let's say that number you're going to have, you're selling an asset, there's $1 million that you're making on it. But on that $1 million, you're going to have your transfer taxes, your broker's fee, maybe there's a flip tax or another building transfer fee. And whatever those numbers are that you're going to owe, those numbers do not have to be part of the reinvestment. So if you're going to be making $1 million, but now you have all of these costs that equal 150,000, then you don't have to reinvest, if the property is a million and that's what, well, let's say it's 2 million. You don't have to invest the full 2 million because you can take off from it that those closing costs. So if somebody's selling a property that they know that they're going to have a lot of closing costs on, maybe they're going to have, who knows, maybe if they're, I was going to say, if they're a foreigner, they wouldn't be doing a 1031 anyway, unless they do it here in the States, which they can, just so you know, foreigners can do 1031 exchanges. The whole risk with respect to foreigners, or I should say, non-US taxpayers, the risk is that somebody sells a property, takes the proceeds, and never pays the government what they owe in capital gains. And so a foreigner would have to bring an application to the Department of Taxation and Finance, and basically it's Form 8228, and it's basically asking for them to look at the paperwork you're submitting and saying to them, I know that I had to send in 20% because I have my purchase price requires that it's over $1 million. It requires me to do 20% to be sent in. However, I'm losing money on this transaction. I paid $3 million for it. So what would happen is we would show the proof of the initial cost, and then we would show what the sale is going to be. And we were able to then say, can we have the money back? And then the Department of Taxation and Finance would give it back. Now, if that same foreigner is going to do a 1031 exchange, they're not taking any, they're not taking any capital gains. So as long as they don't take any capital gains off and they're just reinvesting it into another property in the United States, then they don't have to comply with FRIPTA yet because there's nothing coming off of it. Otherwise, we know that there's a withholding with foreigners. Now, when we're doing a 1031 exchange, I'm often asked whether or not you can do a co-op. There's not anything that says you cannot do a co-op. However, with a co-op, if there's a board approval process and the buyer doesn't get approved and you don't have any time left and you picked 3 co-ops, then you're not going to be able to do a 1031 because you missed the window period. You must close within 180 days of your sale. And if you picked 3 co-ops and now the time's already gone by and you don't have approvals, you're going to have a problem. So it's always crucial that your client identifies properties that they have the greatest likelihood of success of being able to close on. You don't want to list 3 properties that have 4 other interested parties involved and risk that you're not going to get any of them done. I think that it's really important to not wait. People should go out there and once they're in contract, don't wait to close. Find out what you're going to buy while you're still in contract. Go do it immediately and, get yourself into contract and make sure that it's real property. Make sure that there's no reason why there should be a delay on this. And furthermore, make sure that the attorneys are aware of what the plan is here, because if I know that my client's deal is involving a 1031 and I have a buyer on a deal and the buyer's all cash, and in the contract, I state that my client is going to be doing a 1031 and seller shall pay the costs in connection with it, blah, blah, blah. Now, all of a sudden, the buyer decides that they want to close financing. Well, if the buyer wanted to close financing, that can be a very big problem if it's going to delay the closing date, if their time on the 1031 is running out. So your attorney must know these sort of facts so that they can protect against it in the contract. And how would we do that? Well, if I'm representing a seller and the buyer is all cash and they know that I'm doing a 1031, I need to make sure in the contract that I'm stating that the buyer understands that we're doing a 1031, and therefore it would be detrimental for the buyer to delay beyond whatever that date is. Now, obviously, a seller shouldn't be cutting it that close. 180 days is 6 months. So one would like to think that they can get it done within that time frame, but sometimes that just doesn't happen. And remember, that's 180 days. You only had 45 days to identify from the closing. That 45 days is part of the 180 days. So you really your only options are to close the ones that you identified. Again, date and where the monies are received, these time frames, the 45 days, the 180 days, and the need to make sure that the proceeds go and sit with a licensed intermediary is crucial. Now, there are Delaware trusts as well. I'm not going to get into those because I don't personally do them. I did last time I had this class. I believe I had a guest on who does Delaware trusts, and we spoke about that. I could always get Scott on again. But as far as 1031s, the bottom line is this. The rules say, just so to answer that, nagging question of, well, how long does somebody need to be in the property for it to be an investment property? How long do they have to rent it out for? Well, the code doesn't have a black letter answer on it. There's been situations where most accountants will say 2 years. However, let's look at this scenario, and this is where we get into a lot of gray in this topic, which is two people buy a property and it's a 6-family. They're married, they buy it together, and one of them doesn't work. The person that does work passes away. They didn't live in the house. They lived somewhere else. When the husband passed away and they had this investment property that they bought just as an investment, the intention was never to live there. The intention was just to maintain an investment property. Now the husband dies and there's all this debt that the wife didn't know about. So now she doesn't want to keep her house that she had with her husband. She wants to sell the house. She needs to pay off all this debt. She has all these expenses. And so now the best thing for her to do under the circumstances is to move into the investment property, or at least part of it. Now, under those circumstances, if she got audited at some point, she probably would be okay, because the intention when they got the property was to purchase it as an investment property. And then all of a sudden, there was this intervening event that required her either to use all or part of it as an investment. And I mean, as her home, I meant. So now the use has been changed. And then it gets back to what I said earlier, which is now she would be able to offset her gains by the primary residence deduction if she were to sell and have a gain, and the portion that is still rented out, she can still do the 1031 on. And so it's important to really understand not only what those timeframes are, but really who the parties are. We don't want to get into a situation where somebody thinks that they're doing 1031 and it turns out that they're taxed as a partnership. A partnership cannot do a 1031. And so there are things that we really want to look at and make sure. I have had clients come to me many times saying that they are looking into doing a 1031, but it turns out that there wasn't going to be a gain. If there's not a gain, you don't need to do a 1031, just buy a property if you want to buy a property, but you don't need to, you're not going to owe money anyway. So what's the difference? And so, you really want to evaluate that, make sure you understand that. And so, the agents that are out there, you need to know when if a client comes to you and says, I'm going to do a 1031 exchange, do they have a gain? That's crucial. And you can ask them that. Are you going to have a gain when you sell? And maybe they're going to say, not really, maybe not. It depends. Not after paying everybody. And then you don't even need one. So, and I say that because I don't like to be the one that tells the party that, because then they're wondering why you didn't tell them that. So it's just good to kind of, know some of that information. Now, I was saying early on how I find 1031 to be a very good estate planning tool. And I say that because it's a way to move money out of the estate to not pay capital gains. And ultimately, it's possible that the capital gains really never get paid. Because think about this scenario for a second. Bob dies. And at the time that Bob dies, he takes his assets. Let's say he has a building and it's worth, $50 million. And he's getting to a point in his career that, this one, he doesn't really know if he wants to be in that type of portfolio. He has 3 children. Maybe there's some issues in the family. And instead of having one building where they're all going to have to work together, I've seen people go and buy 3 different assets so that each one can take it over. Now, getting back to the capital gains. Let's say hypothetically Bob wants to do that while he's alive. So now he goes and he's going to sell this building, but he's going to make so much money on it. He doesn't want to pay $2 million in capital gains. So instead he decides, I'm just going to buy, now I'm going to, for my estate planning, instead of having the 1 asset, I'm going to go and get the 3. And this way, when something happens to me, my kids can just each inherit the property that I leave to each of them. And if that happens, the kids are going to get the assets at the market value at the time of death. And so, if that happens, think about it. Bob sold the property, didn't pay capital gains, threw it into the new assets. The new assets are in the estate, and the kids inherit them, and they inherit them at the market value at the time of death because the asset is subject to a step up basis. That means that the person that's inheriting is inheriting at the market value at the time of the death, as opposed to at the price that Bob bought it for. So basically what happened through this estate planning, Bob ends up never having paid capital gains on that building, and they kind of got washed away because he passed in that step up basis. And that does happen a lot. It just does. So that's a way, and for estate planning purposes, there are many people out there that when they sell something, they don't necessarily need the cash. And they say, hey, why on earth would I want to pay the gains on this? I'd rather reinvest it, make that much more money on the next property. And why would I want to recognize the gain now? I don't need it. Instead, it's going to be so much more valuable later. And look, at some point in time, like I said, it might not be worth selling, or it's worth selling. With the 1031 exchange, I'm not an intermediary. Some attorneys are intermediaries, but it's really most people that I know that are intermediaries, that's sort of what they do. They are lawyers practicing in 1031s. more so though, there are lawyers that might own they just might be the intermediary, and that's what their career is. They have a firm that does acts as intermediaries, amongst other things. I don't do that. So intermediaries, by the way, charge anywhere between maybe like 1,200 and 2,500. Some of the title companies are also intermediaries. And the intermediaries, basically, the intermediary will send me the paperwork that at the time of closing has to get executed so that I give the intermediary all of the paperwork from the closing so that the intermediary makes sure that they cross every T and dot every I and get everything recorded and filed properly. If the parties are doing the 1031 exchange, as far as cost to the other side, there really isn't any cost. Whoever's doing the 1031 is doing something completely separate and on the side, and the other party's really not impacted by it. And if they were, then the side that's doing the 1031 would have to ultimately pay that cost. I want to talk about the scenario of the person that has a weekend residence and then changes it into an investment property. And so what that looks like is the person that may have been living in the city, full-time, primary resident, owned a house out east, and now it was COVID, and decided during COVID that they were moving the family out east. And they move out east, and now it's their primary residence for the next 3 years. And now they decide nobody wants to be in the Hamptons anymore. And they want to sell it, but they're going to have too much of a gain. And they're going back into the city. So they decide, you know what? It doesn't make sense. It would be a better investment at this point in time to rent it out. They go and they rent it out for 2 years. Is there a clear cut? They have nothing to worry about? Absolutely not. But it's a definite safe bet. There's not going to be fines for it. Your worst case scenario is generally going to be that you'll owe some money. But most of the time, these aren't things that are, no one's going to be able to prove that you intentionally did it to defraud the government. With that said, when somebody calls me up and says, what do I need to do to not pay the capital gains? Like, how long do I have to, what do I have to buy, this and that? We have to be very careful. I told you earlier that in order to qualify for an investment to investment transaction and not pay the gains tax and instead defer the gains tax by doing a 1031, you need to follow those strict guidelines, and you need to make sure that you have an investment to an investment, and you need to understand that it's your intention at the time of the actual purchase of the property that determines what the property is supposed to be used for. So when that woman whose husband passed, when they bought the property, it was intended as an investment. And so when they did the 1031, that was a valid 1031. It'd be very unlikely that they would punish her for that. Circumstances changed, and they'll allow things like that. So it's really case by case, and there's not one answer unless you are following everything to a T. Otherwise, there's going to be this gray area in there. And so in the example I gave you for the Hamptons, we had this property that was clearly a weekend home. They used it more than 15 days. So they had their primary in New York. They would get the deduction if they sold on the gain on the city. But on the Hamptons, that one is not an investment. That was a weekend home. And now when they live in it as their primary and go to sell it, number one, they can still get then the deduction on the primary residence exemption. Or if let's say the market's really down, no one's buying out there, something changed, rates are really high, and it just doesn't make sense to sell at that time. So instead, you rent it out for the next 2 or 3 years, and now you have it created an investment property situation. And it doesn't mean that I can guarantee you that you're not going to get audited and owe money. But if all of these things are true, then you have a very good argument. All right. Take care. Have a good one. And I'll see you next time.